This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
All right, welcome. We're diving deep into a tricky but super important part of contract law, duress and undue influence. Let's get into it. So, here's what we've got on the agenda today. First up, we'll figure out why a yes isn't always a real yes in the eyes of the law. Then, we'll get into the nitty-gritty of duress. That's the law of threats. After that, we'll tackle undue influence, which is all about exploiting trust. We'll put it all into practice with a proper SQE-style problem, and I'll leave you with a killer revision checklist to tie it all together. Sound good? Okay, so first things first, let's set the scene. You're going to see this term vitiating factors all over the SQE syllabus. All it really means is something that, well, messes up a contract. For a contract to stick, the agreement has to be real. It has to be genuine. The law has to have a way to protect people from being backed into a corner or tricked into a deal. And that's where duress and undue influence come in. They're basically the law's way of hitting the pause button and saying, that yes doesn't count. And this is such a great way to think about the difference between the two. You've got duress on one side. It's an obvious, nasty threat. But then you have undue influence. This one is way more subtle. It's like a trusted advisor whispering poison in someone's ear. It's not about a threat. It's about twisting a relationship of trust to get what you want. One's a punch, the other's a poison. Okay, let's dive into our first big topic, duress. This is what we call the law of threats. And honestly, it's the more obvious one of the two because it's all about direct, illegitimate pressure. So duress can take a few forms, like threats of violence or threats to damage someone's property. But the one you really, really need to get your head around is economic duress. It's where someone threatens your business or your finances. And the classic example is threatening to break a contract unless you agree to new unfair terms. So if you see a problem question that smells like economic duress, what do? Well, you pull out this three-part test. It's your checklist. Number 1, was there illegitimate pressure, like a threat to breach a contract? Check. Number 2, was that pressure the reason they caved in? It has to be a significant cause. Check. And number 3, and this is crucial, did they have any other choice? Any reasonable, practical alternative? If the answer's no, you've likely got economic duress. Let's look at how this plays out.
Kafko was a small company that supplied basket goods to a major retailer. They hired Atlas Express to deliver weekly. After the first arrangement was made, Atlas decided the loads were bulkier than they expected and tried to raise the price. One morning, a lorry arrived with a new pre-typed document imposing a minimum charge far above the original rate. The driver was told not to take the goods unless someone at Kafko signed the new terms there and then. Kafko's leaders believed that if the delivery didn't go out, they could lose the retailer contract and the business might collapse. With no time to arrange another haulier, they signed. Kafko later refused to pay the uplift and said the variation, the higher price document, wasn't binding. Atlas sued for the extra money. Now, the legal question is, was the price rise agreement formed under economic duress? Remember, economic duress has 3 essentials. 1. Illegitimate pressure, often a threat to breach an existing contract or exploit a created crisis. 2. The pressure caused the agreement. 3. The victim had no practical choice, and they did not affirm the deal once the pressure lifted. Now, let's examine the case. Firstly, Atlas refused to perform the original bargain and used a threat of immediate non-delivery to force a higher price. The emergency was of Atlas's own making, their miscalculation of load and cost. A demand that says, sign now or we walk away today from an existing commitment is illegitimate pressure. Secondly, Kafko didn't sign because they wanted a new deal. They signed because the driver wouldn't take the goods without it, and a missed shipment risked serious commercial damage with their key customer. Lastly, Kafko, being a small company, had no time to find a substitute carrier that morning, and faced immediate loss if the delivery failed. The court accepted that, in actuality, CAFCO couldn't just shop around in the hour they had. Once the deliveries were safe, CAFCO challenged the uplift and resisted payment. They didn't sit on their hands and treat the higher price as acceptable. What was the decision? The court held that the higher price document was obtained by economic duress. That made the variation voidable at CAFCO's option. The result being that CAFCO was not bound to pay the extra. Atlas couldn't enforce the uplift, and the original delivery arrangement remained the baseline.
All right, so we've covered the big, obvious threats. Now, let's switch gears completely and talk about something sneakier. Undue influence. This isn't about threats, it's about trust. It's an idea that comes from equity, which is the branch of law that's all about fairness. Undue influence is all about one person using their position of power in a relationship to get an unfair advantage. The whole idea is that the weaker person's judgment isn't free or independent anymore because they're being manipulated by someone they trust. And the law gives us two main buckets for this. First, you have Class 1, which is actual undue influence. This is the straightforward one. You, the claimant, have to actually prove that improper pressure was used. The burden's on you. But then there's Class 2, presumed undue influence. And this is where it gets really interesting. Here, the relationship itself is so, questionable that the court presumes there was influence. The tables are turned. Now the stronger party has to prove they didn't do anything wrong. Drilling down into that presumed category, we hit Class 2A. These are what the law calls special relationships. Think solicitor and client, doctor and patient. The relationship itself just screams potential for influence. So the law doesn't even wait for proof. It just automatically presumes it. Now here is your big flashing red light for the exam. Husband and wife is not on this list. So what if your relationship isn't on that special list? Well, that's where Class 2B comes in. This is for any other relationship where you can prove that you placed your trust and confidence in the other person. Remember how husband and wife isn't in 2A? Well, it can fall into 2B if, for example, one spouse can show they left all the financial decisions to the other and just trusted them completely. Okay, pay close attention here. What happens when a bank gets involved? Imagine a wife is asked to guarantee her husband's risky business loan using their family home as security. The deal offers her zero financial benefit, only risk. When a bank sees a situation like that, alarm bells should be ringing. The law says the bank is now put on inquiry. They can't just ignore the red flags. They have a duty to take steps, the big one being to insist that the wife gets her own independent legal advice to make sure she's not being pressured. Right. Theory's done. Let's see how this all works in practice. Time to tackle a problem. So here we go. We've got David, an elderly father. His son Mark needs a massive loan for his failing business. Mark persuades David to guarantee it. The bank knows the family, and the manager just wants to get it done, so he rushes it through. Okay, as you read that, you should be spotting the issues. Elderly father? Check. Potential vulnerability. Son persuading father for son's business? Check. One-sided transaction. A bank is involved? Big check. This is screaming undue influence. All right, first question. What's David's best shot at getting out of this guarantee with the bank? Have a look at the options. Is it A, economic duress, B, actual undue influence, C, that special relationship category, Class 2A, or D, the trust and confidence category, Class 2B, with the bank being put on notice? I'll give you a few seconds. Okay, the answer is D. And let's be really clear why. It's so tempting to see parent and child and jump to Class 2A, right? But that's a trap. That legal presumption applies when a parent influences a young child. Here, it's the other way around. So our best bet is Class 2B. We can argue David placed trust and confidence in his son. And because the loan is only for Mark's benefit, not David's, the bank was absolutely put on inquiry. They failed to take any steps, so they're stuck with constructive notice of the undue influence. That's the winning argument. Okay, let's switch it up. New scenario. Forget the persuasion. What if Mark said, Dad, if you don't sign this loan guarantee, my construction company is walking off the job on your new extension effective immediately. Now what are we dealing with? You got it. Economic duress. See how that one fact changes everything? We've moved away from the subtle world of relationships and trust, and we're smack in the middle of a threat. It's an illegitimate threat to breach another contract used to force him to sign. That is textbook economic duress. All right, let's pull all of this together. This is your final revision checklist. Seriously, if you're going to take a screenshot of one thing today, make it this. So here's the whole topic in a nutshell. Duress equals illegitimate pressure, no other choice. Think of that courier case. Undue influence is all about abusing a relationship. From there, you just follow the path. Do you have to prove it, which is Class 1, or can you presume it, Class 2? If it's presumed, is it a special 2A relationship or a trust and confidence 2B1? And always keep an eye out for a third party like a bank being put on inquiry. If you can walk through this flowchart in your head for any scenario, you're going to be in fantastic shape.
And I'll leave you with this to think about as you revise. Where do you draw the line? I mean, business is tough, right? People drive hard bargains all the time. So when does hard bargaining become illegitimate pressure? The law has to walk this incredibly fine line between letting commerce happen and protecting people who are being coerced. Figuring out where that line is, well, that's what this is all about.